Fellow Bahamians, as I greet you on the heels of this year's National Heroes Day, I wish to express my congratulations to the 300 persons honored by the National Heroes Committee for displaying excellence in their chosen career. I believe that the committee's criteria was stretched to accommodate Bahamians from all walks of life, to include the young, the old, the living, and the dead, with a view to engender support and commitment to this administration into another term. However, I open my communication to you today with the unearthing of one of the most unnerving revelations in recent political history. That while the Davis administration in August hastened to allow the transfer of more than $80 million of the Bahamian people's retirement and pension fund out of the country, and the Supreme Court stalling the process to hear the case for an injunction to prevent that transfer, the BCP has hurried to uncover the true identity and the financial standing of the Island Grid Pike Corporation and its chairman and CEO J. Eric Pike in the international arena. The research and legal team of the BCP has uncovered, through our contacts on the ground in the United States, answers to some questions, but surely have created an even greater concern for the public-private partnership proposed by the government with the Bahamas Grid Company and BPL. As a result of our research and cross-checking, it paints a dismal picture of the integrity of the corporation, of which the nation's chief trustees choose to bring into our country without them having to invest one single dollar. In our search into the history of Pike Corporation, we've uncovered that over the past 20 years, Pike has changed ownership from a private to a publicly traded company in 2006, back to a private company in 2014. This was followed with a multi-company merger with Pioneer Parent Inc. and others in 2024. And that was financed by a three-bank, two major 7.5 year term loan and credit facilities of more than $500 million, collateralizing 100% of both its tangible and intangible equity in its domestic companies and 65% of equity in its foreign subsidiaries rather. This was then coupled and followed by a majority shareholding acquisition of Pike Corporation equity in 2020. While I will not call the names of the bank or the equity company at this time, I guarantee you that you will be appalled to learn from our last dated SEC source that the Pike Corporation is more than 90% owned in the hands of a predatory lender and equity group. And it also appears that based on the U.S. Security and Exchange Commission (SEC), following the return to a private company in 2014, Mr. J. Eric Pike held only 7.5% of the shares, which seemed to be attached to a trust left by his grandparents, with the stipulation that he retain the chairman and CEO of the company founded by his grandfather, Floyd Pike. While there is a myriad of information regarding Mr. Pike's business dealings, there is one thing we can be certain of, is that his dealings do represent a varied and stretched motion of questionable activities, indicating that he cannot be trusted with the people assets in BPL, nor is he qualified to do business with the government of the Bahamas. My fellow Bahamians, while this whole scenario speaks to the detrimental nature of this joint venture deal with Pike and Island Grid, coupled with the fact that the government in its proposal did not mention publicly any concern about Pike's corporation and Eric Pike equity issue, leaves us numbingly nervous that if this deal is sealed, it leaves BPL vulnerable in the hands of international predatory lenders and equity managers who are known to seize control of companies in the energy sector worldwide. So while Prime Minister Davis continues denial of any wrongdoing or missteps on the part of the proposed privatization of BPL, the concern for Pike Corporation's vulnerable position prompted further research to substantiate any response brought by the government in the legal action before the Supreme Court. So at this time, I wish to note that the BCP court action against the Davis administration regarding BPL has just taken a turn that will determine what will happen to this joint venture. On this past Friday, October 11th, the AG office filed a response in the Supreme Court, seeking that the case be struck out and dismissed because they have characterized it as frivolous, a vexation, and an abuse of the process of the court. They have indicated that the BCP is not registered under the Companies Act and is an unincorporated association of persons. Therefore, the BCP and the 5 other applicants, who are all Bahamian citizens, does not have the requisite standing and are not entitled to bring a case against the government to seek remedy before the Supreme Court. The BCP as an organization and the 5 applicants totally rejects the Davis administration's total disrespect for the constitutional rights of the citizens to seek justice regarding the malfeasance of the government and for political organizations to speak for those who cannot speak for themselves. Because our originating notice of application is accompanied by a sworn affidavit by myself as proxy for the other applicants, which legitimated our process to seek an injunction and leave for the judicial review. However, the response by the AG office lacks substance and have refused to address the items of contention, which primarily consist of whether the government received parliamentary approval in the form of a resolution and whether widespread consultation in the bidding process to determine whether the company, Island Grid and Pike Corporation, is a good fit to put the assets of the Bahamian people of BPL in the hands of that company for 25 years. The application to strike out the BCP case on behalf of the Bahamian people further lacks requisite standing, as the sworn affidavit to support their notice of application is not written by any of the 3 named defendants, as should have been done, or the additional 19 cabinet members that are secondarily charged as a collective responsibility. In fact, the sworn affidavit given by a 2-year employee of the Attorney General Office lacks substance, coherence, and the timeline shows that the information is contrived, is hearsay, given with no continuity. This affidavit is therefore seem inappropriate, and that affidavit is considered an abuse of the powers by the AG office. Therefore, their notice to strike out the case must be squashed. The BCP rebukes the government for its lack of due diligence in bringing a company with 90% equity in the hands of predatory lenders to the table, to which, based on its financial standing, does not qualify to do business with the government of the Bahamas. The questions we want answers to are, did the government know that Pike was more than 90% indebted? Was this the reason that the Prime Minister insisted that the money to be injected by Island Grid and Pike be raised locally? Was it Prime Minister's desire to give preferential treatment to this investor or this deal who did not qualify for a joint venture? Was the Bahamas Grid Company Limited incorporated by the Bahamas Power and Light as a subsidiary company? Or was it incorporated in the law offices of Higgs and Johnson, the local attorneys for Island Grid and Pike Corporation, and then used to be what is now being referred to as a special purpose vehicle? Our final question is, what is our government's justification for allowing a foreign-owned company into the Bahamas without injecting a penny into the economy, rather raising the purported capital of $141 million through the Bahamian economy, and within weeks permitting that company to transfer the majority of that capital out of the country? My fellow Bahamians, the BCP is overwhelmed by the degree of impropriety inferred upon this Davis administration regarding this deal with BPL. For while the Bahamian people are promised lower electricity, does that go with the consequences of lower equity in the state-owned BEC and BPL to the detriment of the taxpayers and the Bahamian economy? I think not. However, this very PPP could have been facilitated through the collaboration of a myriad of Bahamian companies doing business with BPL, as the Electricity Act of 2024, 2015, and 1956 permits, as a matter of accountability. However, my fellow Bahamians, when the full unraveling of these matters that are being unearthed is brought to fruition, the very integrity of the stewardship of this entire Davis administration will be called into question. As the BCP continues its crusade on behalf of the Bahamian people, this is S. Ali McIntosh, the servant leader. And as always, may God bless and keep safe the Commonwealth of the Bahamas.